Welcome, everyone, and thank you so much for joining us for today's History at High Noon, the Exum Court and Expansion of Individual Rights, with special guest speaker and author, Justice Mark A. Davis. My name is Stacy, and I handle adult education over at the museum, and we're so glad that you're joining us for this new version of our lunchtime lecture series. History at High Noon is just one of MOH's exciting digital offerings available through our History at Home webpage. If you'd like to learn more about all of those digital offerings, you can head over to the museum's website at www.ncmuseumofhistory.org. Before we get started, we would like to take this opportunity to thank our North Carolina Museum of History Associates and Foundation for making today's event possible. Our Associates and Foundation provide crucial funding and support to the museum, which, in addition to many other things, helps make programs like today's program happen. If you would like to learn more about becoming an Associates member, you can head over to their website at www.ncmoha.com. We would also like to thank those of you who graciously donated funds towards today's program. We endeavor to keep our programming free to attend, but there are costs associated with keeping these series going, and we continue to appreciate your generosity and support. A few housekeeping tips for today. We ask that you please keep your mic muted throughout the entirety of the program, and that if you have any questions for our speaker, to please type them into the chat function located at the bottom center of your screen. At the end of the lecture, I will ask the speaker as many of your questions as time allows. We also have a special treat as part of today's lecture. Justice Davis has offered to autograph his book, A Warren Court of Our Own, the Exum Court and the Expansion of Individual Rights in North Carolina, as part of today's program. You can order your copy of the book on our museum shop website or by heading into the museum shop. The website for ordering is www.ncmuseumofhistoryshop.com. It will be signed and mailed to you while supplies last. All right, so now it is my honor to introduce today's speaker, Justice Mark A. Davis. Justice Davis was appointed to the Supreme Court of North Carolina in March 2019. Prior to that, he served as an associate judge on the North Carolina Court of Appeals for over 6 years. He worked as a special deputy attorney general in the North Carolina Department of Justice for 5 years. He spent 13 years as an attorney at Womble, Carlisle, Sandridge, and Rice, where he was a member of the firm in the litigation section. He also served as general counsel in the office of the governor for approximately 2 years. Justice Davis received his law degree from the University of North Carolina School of Law and served on the North Carolina Law Review. He received his undergraduate degree from the University of North Carolina at Chapel Hill, where he was inducted to the Phi Beta Kappa. Upon graduation from law school, he served as a law clerk for the Honorable Franklin T. Dupre, Jr. in the United States District Court for the Eastern District of North Carolina. Justice Davis has been active in the North Carolina Bar Association, serving as vice president and member of the Appellate Rules Committee and the Bench Bar Liaison Committee. In 2018, he received a Master of Laws, an LLM degree in Judicial Studies from the Duke University School of Law. He is also a recipient of the Order of the Longleaf Pine. Justice Davis has given presentations at numerous continuing legal education seminars in North Carolina on the subject of appellate advocacy. He is the author of a book on the North Carolina Supreme Court entitled A Warren Court of Our Own, the Exum Court, and the Expansion of Individual Rights in North Carolina, as I mentioned before. He and his wife, Marcia, have been married since 1992 and have 3 children. Okay, so Justice Davis, I'm going to turn it over to you. Welcome. Thanks for joining us today.
Stacey, thank you so much for the kind introduction, and I'm so grateful to everybody who is participating. I wish this could be in person, but this is the next best thing. My name is Mark Davis. I do have the honor of serving on the North Carolina Supreme Court, and it's a delight for me to talk about this book, which I wrote while I was serving as a judge on the North Carolina Court of Appeals a few years ago. The name of the book, as Stacey said, is A Warren Court of Our Own, and it's about the period of the court on which I now sit, the North Carolina Supreme Court, when Jim Exum was Chief Justice between 1986 and 1995. I write about this court because to me it's always been sort of a Mount Rushmore court in North Carolina. The justices who served on that court were all luminaries whose names will live on in North Carolina law for decades to come. In addition to Chief Justice Exum himself, you had 4 other future Chief Justices on the court, including Burleigh Mitchell, Henry Frye, Beverly Lake Jr., and Sarah Parker. You also had incredibly talented and bright Associate Justices like Willis Richard, Harry Martin, and Lewis Meyer. 6 of the 9 members who served on the Exum Court were alive and were gracious enough to let me interview them extensively about that period in the court's history. I also interviewed about 65 former law clerks from that era, attorneys who practiced law during that era, court personnel, and law professors, because I really wanted to get a fully balanced picture of that era of the court. Jim Exum himself was kind enough to write a foreword for the book, which I greatly appreciated and I think is very well done. So the title, A Warren Court of Our Own, is sort of an obvious analogy to the period of the United States Supreme Court that existed in the 1950s and 60s under Chief Justice Earl Warren. And as many of you know, that was a particularly controversial era for the US Supreme Court. Chief Justice Warren presided over what some thought was a radical expansion of the liberties contained in the Bill of Rights in the federal Constitution. And the premise of my book is that, admittedly on a somewhat smaller scale, the Exum Court was North Carolina's version of the Warren Court in that it substantially modernized North Carolina law in a way that really had never been done before. And I'll talk more in detail about that in a few minutes. In the time I have today, I'd like to talk about three topics that are discussed much more in depth in the book. The first is how the Exum Court came to exist. The second, I want to talk about the personalities and the differing judicial philosophies of the members of the Exum Court. And third, I'd like to talk about some of the landmark cases decided by that era of the court. In other words, why the court was significant. So the first topic is how the Exum Court came to be, and the subtitle of that is A History of Judicial Partisan Elections in North Carolina. So I'm, as somebody who's lived in North Carolina his entire life and really never been terribly political, I sort of had this vague notion that the Democratic Party had been instrumental in controlling state government during the 20th century. But until I started researching the book, I really did not know how extensive that control had been, particularly in the judicial branch. As of 1986, which is when Jim Exum became Chief Justice, the last Republican elected to the state Supreme Court was elected back in 1896. Think about that, 90 years earlier. And that person was defeated in 1904, probably because he was a Republican. No Republican candidate had ever prevailed in a statewide judicial race in the entire 20th century. What you had on the Supreme Court of North Carolina was sort of a de facto appointive system, where Democratic governors would appoint Democratic justices who would serve as long as they wanted to until they reached the mandatory retirement age of 72, and then the process would repeat itself. So for most of the 20th century, Democrats controlled all three branches of government. But in the 1960s, some of you may recall or may have read about the so-called Southern strategy that the National Republican Party used to try to attract more Southern voters to the GOP fold. And they had some success. 1972 was a particularly watershed year for Republicans in North Carolina and in some other Southern states. You had Richard Nixon, of course, pre-Watergate, who was popular in North Carolina and carried the state. You had Jesse Helms winning the first of his U.S. Senate terms. And you had a Republican named Jim Holshouser, who was elected as governor, which was a big deal in North Carolina. In 1976, things sort of went back to normal. Jimmy Carter carried the state as a Democrat, and Jim Hunt, a Democrat, won the first of his 4 gubernatorial terms. But if you flash forward to 1984, things get really interesting. Another popular Republican, Jim Martin, was elected as governor. Another popular Republican president, Ronald Reagan, easily carried the state. And Jesse Helms won a very bitterly contested U.S. Senate race over Jim Hunt. But so far, none of this upper ballot success had trickled down to lower ballot races like judicial races. Why was this? Well, several reasons. First, then as now, judicial races have always been less visible in the media and in the public eye. Also, then as now, there was little voter information about judicial candidates, and a lot of people just relied on their party registration, which was still a majority Democrat registration in North Carolina at that time. And also the courthouse crowd in virtually all 100 counties was solidly Democratic. So when people would ask their judge friends, their lawyer friends, who to vote for the Supreme Court, they were almost always advised to vote for the Democratic candidates. Now, I mentioned a moment ago that Jim Holshouser was elected as a Republican governor in 1972, but he only served one term and he did not have the opportunity to make any appointments to the Supreme Court. But Governor Jim Martin in the 80s had a little more luck in this regard. In 1985, 1 year into his first term, there was a retirement on the Supreme Court, and Governor Martin appointed a woman named Rhoda Billings, who was a very well-regarded Wake Forest University law professor who happened to be a Republican. Then in June of 1986, things got really interesting. And I'm going to talk for the next couple of minutes about a series of events. And please keep in mind that all of these events happened during the 5-month period between June of 1986 and North Carolina's regularly scheduled elections in November. So in June of 1986, the longtime Chief Justice Joseph Branch unexpectedly announced his retirement. Now, the longstanding tradition at that time was that when there was a vacancy in the position of Chief Justice through a retirement or a death, the governor would elevate the senior associate justice, the member of the court who had been on the court the longest. And that was Jim Exum. Jim Exum had been on the court since 1975. He wanted to be Chief Justice, and he thought that he was entitled to be appointed based on this tradition. And Governor Martin, well, we had sort of an unusual situation, though, because for the first time in anyone's memory, we had a Republican governor, Jim Martin, and a Democratic senior associate justice, Jim Exum. And the question was, what was Governor Martin going to do? Well, he was lobbied very strongly, both inside and outside the legal community in North Carolina, to follow the tradition and elevate Jim Exum. But Governor Martin had views of his own about North Carolina. He wanted North Carolina to truly be a two-party state at every level and at the highest levels. And so he shocked everybody by elevating not Jim Exum, but Rhoda Billings to be the new Chief Justice. And this was a very big deal in North Carolina judicial circles and legal circles. When I was writing the book, I had the opportunity to interview Governor Martin, which I greatly appreciated. And it was a delight to meet him and talk to him. And during the interview, I asked him point blank, I said, Governor, so why didn't you follow the North Carolina tradition and elevate Jim Exum? And he smiled at me and said, Mark, it wasn't a North Carolina tradition. It was a Democratic Party tradition, which I thought was a fair answer. But in any event, Jim Exum had a decision to make. He could have done nothing. His seat as an associate justice was not on the ballot in November, so he could have kept his safe seat, stayed on the court, and bided his time for a future election cycle to run for Chief Justice. But instead, he did something different. He wanted to be Chief Justice. He thought he had been unfairly passed over, and he wanted to run against Rhoda Billings. And keep in mind that by a quirk of North Carolina's election laws, even though she had just been appointed a few months earlier, she still had to run in November, a few months later, to keep her seat. So Jim Exum announced he was going to run against Rhoda Billings in November for the Chief Justice position. And in a very courageous move, he resigned his seat as an associate justice because he thought it was unseemly for two members of the court to be running against each other. So at that point, Governor Martin had another vacancy to fill. He appointed a former Superior Court judge from Greenville named Robert Browning. And I neglected to mention a few minutes ago, at the time he elevated Rhoda Billings to Chief Justice, Governor Martin also appointed a Republican lawyer named Francis Parker from Charlotte to fill the vacancy in Chief Justice Billings' Associate Justice position. So now, after all these years and years of complete Democratic control, you now had a 4-3 court. You had 4 Democrats, 3 Republicans, and a Republican Chief Justice. And you also, as luck would have it, or ironically, some would say, 2 of the incumbent Democrats were also scheduled to be on the ballot already as part of their regular election cycle, Harry Martin and Lewis Meyer. And they too had Republican opposition. So again, for the first time in anyone's memory, North Carolina had partisan Supreme Court races in the fall of 1986. And most of the attention in the media and in the public eye was on the Chief Justice race, Rhoda Billings versus Jim Exum. And for the first time, we saw negative campaigning in a judicial race in North Carolina, we saw a grassroots group called the CCC, the Citizens for a Conservative Court, and they formed for the sole purpose of attacking Justice Exum, and they did it on one issue. They did it on the death penalty. Jim Exum was a known opponent of the death penalty. He had sought to abolish it as a legislator, and he had frequently dissented as an associate justice in a number of cases when the majority of the court had affirmed a defendant's death penalty conviction. He didn't believe that the death penalty was always unconstitutional, but he believed it was being applied unconstitutionally in North Carolina. So what the CCC would do is they would hold demonstrations at various counties, courthouses in North Carolina where prominent murder cases had arisen, in which Justice Exum had written a dissent arguing for the overturning of the defendant's death penalty sentence. And this enraged a lot of lawyers who didn't like the tactics of the CCC, and they respected Justice Exum, and they would hold counter demonstrations across the street from where the CCC was demonstrating and try to explain to people that Exum was just doing his job and applying the law the way he saw it. We sit here now in 2020 in an age of super PACs and independent expenditure groups and the so-called Citizens United outside money. And it all sounds so primitive to us, and maybe it was primitive, but this is where negative campaigning in judicial races started in North Carolina. So again, this was such an unprecedented cycle in so many ways for the North Carolina Supreme Court. What ultimately happened? I've told you the backdrop, the story of how the races were shaped up and the negative campaigning and the counter demonstrations. What was the result? Well, the result was anticlimactic. All the Democrats won in November, as they always had, and it went back to being a 7-0 Democratic court, and Jim Exum became Chief Justice on November 26th of 1986. And that's really where the heart of the book starts. But I do think that history of partisan judicial elections in North Carolina is interesting, and I hope you do as well. And again, it's discussed more fully in the book. So let me shift gears and talk about the members who served on the court during the Exum Court, starting with Chief Justice Exum himself. All of these were legendary figures, and I tried to include as much of a biographical sketch as I could as to each of them in the book, because they really all were just brilliant judges who led very interesting lives and continue to do so in some cases. Jim Exum was born in the tiny town of Snow Hill, North Carolina in Greene County. He was a Morehead scholar and then went to NYU Law School in New York City. And he says, and some think that that's where he acquired some of his progressive views that were not always in line with some of the more traditional views in legal circles in North Carolina. He came back to North Carolina, and he was one of the first persons to serve as a law clerk on the North Carolina Supreme Court. Then he went to practice law at a law firm in Greensboro. He ran for the North Carolina House successfully. And then he was appointed to a vacancy, appointed to a new position as a Superior Court judge in Guilford County. He was then elected to an open seat on the Supreme Court in 1974. Just as a digression, going back to the long history of Democratic control of the Supreme Court, I think it's interesting that when he ran for the Supreme Court for the open seat in 1974, he had two Democratic opponents in the primary, and then he ran unopposed in the general election. The Supreme Court that he joined in 1975 was, by all accounts, a very conservative court. It was perceived as rarely ruling for criminal defendants or for plaintiffs who were suing against big corporations or against the government. As the junior justice on the court, he was not afraid to ruffle a few feathers. He looked and acted differently than his colleagues, who were all at least a generation older. One of them told him he needed to get a haircut because he looked, he had the modern youthful look of the time that not many members of the court had. But he was very much an intellectual who thought about the law in broad, abstract terms. In his personal life, I think his most interesting hobby is he was well known as a huge motorcycle enthusiast. He once rode his bike all the way to Alaska and rode it through Europe. So that was one of his passions, in addition to the law. If you think of the book as involving characters rather than real people, the other prominent, I'd say the other central figure or character in the book was Lewis Meyer, who was the senior associate justice during all 8 years of the Exum Court. His views on being a judge were 180 degrees different from those of Exum. And even though they were close friends, they clashed repeatedly on cases and on the proper role of judges. And I'll talk more about that in a few minutes. Justice Meyer was also born in a small town, Enfield, North Carolina. He grew up in a very poor family. He was a double deacon at Wake Forest University. He first met Exum when he too served as a law clerk on the North Carolina Supreme Court. He then went to work for the FBI and did some really interesting secret things in New Mexico. He then came back to North Carolina, practiced law in Wilson, and had a successful practice in utilities law, insurance defense, and as a police attorney. In 1981, he was appointed by Governor Hunt to the court. While on the Supreme Court, he was simultaneously an imposing but a beloved figure. He was fond of walking down the hallways of the court, sticking his head in people's doorways and asking them, "Are you happy in your work? Are you happy in your work?" It seems like every single person I interviewed for this project, whenever I mentioned Louis Meyer for the first time, they would stop me and say, "Has anyone told you how we'd come into our office randomly and just ask us if we were happy in our work?" But that was really his trademark. He loved his job and he wanted everyone else to be happy as well. He was known as the court conservative. He was perceived as being pro-government, pro-business. He was also the great dissenter on the Exum Court. He was often not in the majority, and as a result, he wrote a lot of very scathing dissents, and I try to quote from as many of them as possible in the book. But he was constantly worried that the Supreme Court under Chief Justice Eckson was moving too far to the left, as he saw it. After Justice Meyer was Justice Burleigh Mitchell, another fascinating figure. Justice Mitchell, by his own accounts, had a very rebellious youth. He ran away to join the Marines at the age of 16. When they found out his age, they sent him home. He dropped out of high school to join the Navy and then served in combat in Southeast Asia. He then returned home to North Carolina, finished college in 3 years, and then went to law school. He worked for the North Carolina Department of Justice. He was elected as the district attorney for Wake County. He served on the North Carolina Court of Appeals. Then he was appointed as the Secretary of Crime Control and Public Safety, as it was then called, under Governor Hunt. And then Governor Hunt appointed him to the Supreme Court in 1982. As a justice, Burleigh Mitchell was widely admired for his strong intellect and his pragmatism. He didn't believe in writing long scholarly dissertations in his opinions. He liked to just explain why he was reaching the result he was reaching and then move on. In his personal life, he loved hunting and fishing. He was a great outdoorsman. And as I say in the book, he was probably the only appellate judge in North Carolina history with a large stuffed boar's head prominently mounted in his office, which he loved talking about to visitors. After Burleigh Mitchell was the legendary Henry Frye, who of course served as the first African-American in the history of the North Carolina Supreme Court. Justice Frye's life could easily be a Hollywood movie. He grew up in segregated Richmond County. He tells a very sad and poignant story about how he was denied the right to vote on his wedding day. He was given an impromptu literacy test by a white registrar who asked him, among other things, to name all the signers of the Declaration of Independence and everybody who had signed the North Carolina Constitution, a test that none of us could pass. He served his country in the Air Force. He went to UNC Law School, where he was the only African-American student in his class. He worked in private practice in Greensboro. He started his own bank. He thought that African-Americans were underserved at the time by mainstream banks, and so he wanted to start a bank that would cater to African-Americans and people of low socioeconomic status. He served terms in the North Carolina House of Representatives and the Senate, and then he was appointed by Governor Hunt to the Supreme Court in 1983. He is widely known as a civil rights pioneer, and appropriately so, but not everyone knows that he also brought an expertise in insurance law and a business savvy to the court, which was greatly appreciated by the other members of the court. He was fond of reciting witty poems at public events, and if you've ever had the pleasure of hearing Justice Frye speak, it is a wonderful thing. After him was Justice John Webb. Justice Webb served in World War II. Then he went to Columbia Law School in the Ivy Leagues. He practiced law at Franklin Delano Roosevelt's old Wall Street firm in New York. And then he returned to Wilson, North Carolina to form a law firm. He was a Superior Court judge for 6 years. He earned the nickname the Smiling Cobra. And the reason for that nickname was He was a very kind and pleasant person, and he was in the habit of always smiling at people, and he would do so even when he was sentencing criminal defendants, sometimes to very harsh sentences, and hence the name the Smiling Cobra. He served on the Court of Appeals for 9 years, and he joined the court in 1986 by defeating Francis Parker during the legendary 1986 elections that I talked about a few minutes ago. Justice Webb was the quietest member of the court, but he was very well read. He was considered a scholar on Winston Churchill. He wrote his own opinions. He didn't use his law clerks as much as the other members of the court, and he took pride in writing in a very plain, folksy, plain-spoken style. So if you run across Justice Webb opinion, you will recognize it instantly for its brevity. And in my opinion, he was sort of in the center philosophically in terms of judicial philosophy on the Exum Court. The next was Willis Richard. Justice Richard excelled at UNC in both college and law school. He too clerked on the North Carolina Supreme Court. He practiced law in Durham, and then he spent 2 terms in the North Carolina House, 3 terms in the Senate. He was primarily responsible for the passage of the Coastal Area Management Act. He is the only person in North Carolina history to ever serve in both chambers of North Carolina's legislature and on both of North Carolina's appellate courts, a record that will almost certainly never be broken. He was appointed to the Court of Appeals by Governor Hunt, and he joined the court in 1986 in those same legendary elections by defeating Robert Browning. The Exum Court was a court of scholars, but Willis Richard may have been the scholar among scholars. Very, very much an intellectual. He was very fastidious about proper legal citations, and more than one member of the court told me in interviews that before they would circulate their opinions to the other members of the court, they would run them by Justice Richard first to make sure that they looked in apple pie order. After Justice Richard was Harry Martin, another legendary figure in North Carolina law. He was 5 feet 6 inches tall. He only weighed 130 pounds, but despite being small in stature, he really had a great, great intellect. He grew up during the Depression. He worked as a professional musician before attending UNC. He served in the Air Force during World War II and then went to Harvard Law School. Came back to North Carolina, was a special Superior Court judge on the Court of Appeals for 4 years, and he was appointed by Governor Hunt in 1982 to the Supreme Court. Justice Martin had a very quirky sense of humor. While on the Court of Appeals, he wrote one of my favorite Court of Appeals opinions ever. The case had to do with a law that regulated the use of dogs in hunting in North Carolina, and he used the opinion to go off on a description of prominent dogs referenced in judicial opinions and in literature. It led another member of his panel in that case, former Chief Judge Hedrick, to write a separate concurrence saying, "I agree with the result reached by my colleague. I write separately only to note my objection to his dissertation, however learned, on dogs." Justice Martin was known for his seersucker suits, his bow ties, and his sense of humor. He was very proud to be a liberal. He was always looking out for the little guy and was a great admirer of U.S. Supreme Court Justice William Brennan. When he approached the mandatory retirement age of 72, he didn't want to leave the court. So what did he do? He filed a lawsuit challenging the 72 retirement age in statute as unconstitutional. It went to his court. He obviously did not participate in the case, and the court had to rule 6-0 against him and ruled that the age limit was unconstitutional. As a result, he was forced to resign upon reaching age 72 in 1991, and he was replaced by Beverly Lake Jr., who sadly passed away last year, who some of you knew. Governor Martin was in his final 2 years as governor, and he appointed Beverly Lake Jr. to replace Harry Martin. Beverly Lake Jr. is on the short list of father-son combinations who have served in the North Carolina Supreme Court. He actually was born a Democrat, and in his early adult life, he switched parties to become a Republican. He served as a Superior Court judge for 5 years. He spent 2 terms in the Senate. He actually ran against Jim Hunt for governor in 1980 unsuccessfully. Justice Lake was known as the consummate Southern gentleman, and he was the only Republican to serve on the 8 years of the Exum Court, but he only served 1 year. Under North Carolina's election law, As an appointee, he was required to run to keep his seat in the next election, which was in 1992, and he was defeated by Sarah Parker, who many of us know very well. Justice Parker served on the final 2 years of the Exum Court in this seat. She, of course, has had a legendary life herself. After college, she went to Turkey to serve in the Peace Corps. Then she came back to UNC Law School. She was only one of 8 women in her class and only one of 5 who graduated. She then went to Charlotte, was in private practice for a number of years before being appointed to the Court of Appeals by Jim Hunt. She was the only woman on the Exum Court. Throughout her career, she was known for her intellectual and studious approach as a judge. So let me talk in my remaining time about the operation of the Exum Court. It was a very collegial court. If you're my age or older and you've worked in downtown Raleigh for much of your life as I have, you may recall the sight of the entire Supreme Court during this era walking en masse to one of several favored restaurants, as my wife likes to say, like little ducks in a row, in order of seniority. They would eat together virtually every day, and they enjoyed each other's company. But despite getting along so well, the court, and despite the fact that other than the 1 year of Beverly Lake Jr., even though the court consisted largely of justices who were of the same political party and shared many of the same demographic characteristics, they had very different views on judicial philosophy and the proper role of judges. And that, to me, is really the essence of why this court was so fascinating. I think of Exum and Meyer as the 2 intellectual centers of gravity, each on opposing ends of the spectrum in cases involving individual rights. Like many judges, I always cringe when the media tries to describe judges as either liberal or conservative because those terms have acquired so much baggage, it's not really clear what they mean anymore. But for what it's worth, Exum was sort of regarded as the classic example stereotype of a liberal judge. He tended to see the law in idealistic terms. He was sympathetic to the underdog, and he was not opposed to overruling prior decisions from the Supreme Court when he thought appropriate. Lewis Meyer, conversely, was often regarded as a stereotypical conservative judge. He was perceived to be a law and order judge who, as I said earlier, frequently ruled for the government in civil and criminal cases and for business. He very much believed that policy decisions were reserved exclusively for the General Assembly and not for the judicial branch. Because Exum usually had a reliable voting majority, Meyer was often in dissent, often by himself. And as I mentioned earlier, he would write very scathing dissents, accusing the majority of being result-oriented and improperly making the law or legislating from the bench. So in the book, I talk about in some detail about 65 cases from the court that I think were very important to North Carolina law. I try to divide them up by subject matter. I talk about cases involving the North Carolina Constitution, criminal law generally, the death penalty, personal injury law, employment law, and workers' compensation law. And I'll just talk very quickly about some or all of those topics. The North Carolina Constitution is interesting because during the Warren Court, civil libertarians were winning all their cases at the federal level, and there really was no need to look to state constitutions for protection of individual rights. But once the Warren Court ended and the U.S. Supreme Court tilted to the right a little bit, a lot of people began looking to the state constitution, and North Carolina was no exception. Jim Exum and Harry Martin in particular embraced the notion that the North Carolina Constitution was a totally separate ground for protecting individual liberties. And Justice Martin in particular would go around the state and make speeches to attorneys and urge them to bring cases under the North Carolina Constitution. And he would remind them that when there were individual rights that were contained in both the Federal Bill of Rights and the North Carolina Constitution, for example, the free speech provision, that what the U.S. Supreme Court, how they interpreted federal free speech was just the floor. It wasn't the ceiling. And North Carolina's Supreme Court had the right under the state constitution to create a higher ceiling and give a greater protection of those parallel rights, such as free speech. Lewis Meyer conversely believed that state constitutional provisions should be interpreted narrowly and not be interpreted greater than the parallel provisions in the U.S. Supreme Court, or in the U.S. Constitution by the U.S. Supreme Court. In criminal cases, The Exum Court showed a repeated willingness to overturn criminal convictions on a variety of different theories. They were often unwilling to excuse as merely harmless error violations of right, either procedural or substantive, that were conferred by the Constitution or by statute that a criminal defendant argued had been violated in his or her particular case. And the Exum Court was more likely to give a fresh listen and take those arguments more seriously in some cases than prior versions of the Supreme Court would have been likely to do so. In the book, there's a separate section on the death penalty because I thought that merited its own discussion. One of the most remarkable statistics that I came across in writing this book is that the Exum Court in its 8 years faced or heard cases involving 163 challenges to the death penalty verdicts. And of those 163, they overturned 102 of them for a reversal rate of over 62%. And that is really, really staggering. In today's world on our court, anytime we overturn a death penalty conviction, it is a big deal. And it doesn't happen very often. And they did it 102 times out of 163. Now, in fairness, that was a time when the U.S. Supreme Court was having a difficult time coming to a consensus within its own court about what state laws involving the death penalty were and were not constitutional. So they kept changing their mind and their opinions, and as a result, state courts like the Exum Court had to catch up. So it wasn't entirely the result of judicial philosophies within the Exum Court, but that did play a part of it. Jim Exum clashed repeatedly over the death penalty with Justice Meyer and Justice Mitchell. On a number of grounds, they would overturn death sentences, one of which was based on proportionality review, whereby the court had to look at the existing pool of death penalty cases in North Carolina to make sure that the imposition of the death penalty in the case before them was not disproportionate to the penalty imposed in past cases involving similar facts. And Exum in particular was known for refusing to allow a death penalty verdict to stand when he had trouble understanding how the facts of the case before him were more egregious than other cases involving similarly or even more egregious facts for which jurors had not recommended the death penalty. Justice Meyer, conversely, was much more inclined to defer to the judgment of the jury which had imposed the death penalty, and therefore he was much less willing to overturn death sentences. In civil cases, the Exum Court displayed a willingness to expand individual remedies available to individual plaintiffs beyond those that had been historically recognized by the North Carolina Supreme Court, which led Justice Meyer to often express his concern that the court was becoming too plaintiff-friendly, too plaintiff-oriented, and that was a concern to him. In employment law, the Exum Court consistently gave greater rights to workers when suing their employers. One case in particular I'll mention, a case called Coman versus Thomas Manufacturing Company, which is certainly still remains a landmark case in North Carolina. It had to do with the employment at will rule, which says that normally if an employee does not have a contract of employment, they can be fired at any time for any reason or no reason at all. And there was a long line of cases from the North Carolina Supreme Court always affirming the validity of this employment at will doctrine. Well, in Coman, you had a truck driver who was at will. He did not have a contract of employment, and he was ordered by his employer to falsify his travel logs in violation of federal law. And he didn't want to do it, and he was essentially fired, and his lawyer did sort of a legal Hail Mary. The lawyer said to the Supreme Court, look, this is wrong. I'm not sure exactly why it's wrong, but this should not be the law, that someone can be fired for refusing to violate federal law. And he picked the right court to make that argument too. The Exum Court was in fact receptive to that argument. In an opinion by Harry Martin, for the first time, the court created a judicial exception to the employment at will doctrine for firings that violated North Carolina public policy. Justice Meyer read a very vigorous dissent in which he argued that any such remedy should come from the legislature rather than from the court. And he worried about the proliferation of frivolous lawsuits that would ensue and about employers being afraid to fire at-will employees even when they deserved it. Workers' compensation law is usually a dry topic that generally does not generate a lot of controversy, but it did on the Exum Court. It was the subject of many, many philosophical battles between, in particular, Exum and Meyer. The workers' comp laws, which of course provide for monetary compensation to workers who were injured on the job, had first been passed in North Carolina, the workers' comp laws, in 1929. And Exum and Meyer had very different views on how that law should be interpreted. Exum believed that the workers' comp statutes should be read and construed as broadly as possible to give the maximum amount of recovery to injured workers. Justice Meyer, conversely, felt that the workers' comp statutes had been enacted as a very delicately crafted compromise between all of the stakeholders in the North Carolina legislature, such that he didn't believe that courts should interpret it one iota more liberally than what the plain text of the statute said. And one of the landmark cases that was decided by the Exum Court involving workers' comp law was a case called Woodson versus Roland, which was decided in 1991 and at the time was an incredibly big deal in the legal and business community. It had to do with the so-called exclusivity rule. That rule provides that when a worker is injured on the job, their only recourse against their employer is to seek workers' compensation benefits under the Workers' Compensation Act in a special tribunal called the North Carolina Industrial Commission. In other words, they're not allowed to sue their employer in Superior Court and seek punitive damages, a jury trial, etc. So in Woodson, it had very sad facts. A construction worker was literally buried alive when the trench he was digging had collapsed after his employer had ordered him to do so without using safety equipment. And he tried to, his lawyer, his estate, tried to sue the employer in Superior Court. And the employer argued that under the exclusivity rule, the employer could only be sued for workers' compensation benefits in the Industrial Commission. And there was a long line of cases from the North Carolina Supreme Court up until that time, holding that even in cases involving gross negligence by an employer, that it still was not enough to overcome the exclusivity rule. But the Exum Court, again, looked at things a little differently, and in an opinion written by Exum himself, they changed the law and created an exception to the exclusivity rule that had never existed before. The court held that a negligence lawsuit could be brought in Superior Court, seeking a jury trial, damages, etc., if there was enough evidence for the jury to find that the employer's actions were not just grossly negligent, but so egregious as to be substantially certain to cause death or serious harm to the employee. And Justice Mitchell and Justice Meyer dissented. They felt that the majority was usurping the role of the legislature. And as I said a minute ago, there was a huge outcry in this case. There was a concern, a strong concern by the defense bar, the civil defense bar, and the employment community, the business community, that the exclusivity rule had just essentially been eviscerated. In fact, the Supreme Court has sort of walked back the decision in Woodson over the years. And to my knowledge, the Supreme Court has never allowed a Woodson claim to go forward to trial in the some 30 years since the Woodson case was decided. But at the time, it was just had a huge impact on North Carolina's law. Sometimes people ask me about the book, what case do I think epitomizes the Exum Court? And I'll tell you quickly the case that I think falls into that category. It's a criminal case. It's called State v. Carter that arose under the North Carolina Constitution. So North Carolina, just as by way of background, has a provision comparable to the Fourth Amendment in the Federal Bill of Rights, which prohibits unreasonable searches and seizures. And so both under that provision, like the federal provision, there is a doctrine that some of you are familiar with called the Exclusionary Rule, which means that if evidence was obtained unconstitutionally against a criminal defendant, it cannot be used in court to convict the defendant at his trial. And so In State v. Carter, you had just a horrible, horrible crime. An elderly woman was viciously raped and assaulted. And the police suspected the defendant of being the perpetrator. A police officer went to a magistrate and sought a warrant to take a blood sample from the defendant to try to match his blood to the blood found at the scene of the crime. The magistrate issued the warrant for reasons I will not bore you with. It was later agreed by everyone that the magistrate had erred, that there was no probable cause to issue the warrant. But in any event, the warrant was issued, the blood sample was taken, and it matched the blood of the victim during the offense, and the defendant, not surprisingly, was convicted. And the issue before the Exum Court was whether there was a good faith exception to the exclusionary rule. So about 2 years earlier, the U.S. Supreme Court, in interpreting the federal exclusionary rule, had ruled in a case called United States versus Leon that yes, there was such a thing as a good faith exception to the exclusionary rule. The U.S. Supreme Court had ruled that when a law enforcement officer violates a suspect's Fourth Amendment rights in gathering evidence against that defendant, the exclusionary rule would not apply to bar the use of that evidence at trial if the officer had acted in good faith on a judicial official in gathering the evidence. And so in this case, in State versus Carter, which again was under the North Carolina Constitution, not under the federal Constitution, the state argued that even though they conceded that no probable cause had existed for the magistrate to issue the warrant for the defendant's blood sample, they argued that the officer who took the blood sample and used it had done so in good faith reliance on the magistrate's ruling, and that therefore, as in the U.S. Supreme Court case, the North Carolina Supreme Court should adopt an exception, a good faith exception to the exclusionary rule. Instead, the Exum Court disagreed with the state. In an opinion also written by Harry Martin, a very bitterly divided 4-3 opinion, the Exum Court refused to adopt the good faith exception. They used very lofty rhetoric to defend the exclusionary rule, and they flat out refused to follow the federal approach. There was a very, very bitter dissent by Burleigh Mitchell, joined by Lewis Meyer and John Webb, blasting the majority and warning that the decision would result in criminals going free based on honest mistakes by law enforcement. Now, let me just say quickly as an aside, in North Carolina, we elect judges. We don't appoint them like happens in the federal system. And one of the criticisms that's frequently raised against electing judges is the fear that they will be afraid to make unpopular rulings. And I think the Exum Court just went against that stereotype so much. In this case, illustrates that better than perhaps any other. You had a horrible, horrible crime. You had a defendant that everyone knew was guilty, because even though the blood sample had been unconstitutionally obtained, once it was tested, it showed that the defendant was in fact guilty based on the blood sample. So, and you had a U.S. Supreme Court case decided 2 years earlier, which had authorized a good faith exception under the Fourth Amendment. And there was a long line of cases from the North Carolina Supreme Court up to that point, following the U.S. Supreme Court, their Fourth Amendment jurisprudence in interpreting North Carolina's parallel provision in the North Carolina Constitution. So for all of those reasons, nothing would have been easier than for the Exum Court to simply go along with the U.S. Supreme Court and say, we also are going to adopt a good faith exception and affirm this defendant's conviction of this horrible crime. But they didn't do it. It was really an act of courage on the part of the Exum Court. And whether you agree legally with their basis for ruling the way they did, you really cannot help but admire the courage that the court showed in reaching that ruling. So as I'm running out of time, let me wind up. All things must end, and so too the Exum Court. Jim Exum shocked everyone by retiring at the end of 1994, well younger than the mandatory retirement age of 72. He was worn down primarily because of all the death penalty cases. He went back to Greensboro to practice law and teach at Elon Law School. In what some would call poetic irony, Lewis Meyer also left the court at the same time. He did not leave by choice. He was defeated. He was challenged successfully in the Democratic primary by some folks who thought he was a little too conservative, and he lost, and he was appointed by Governor Hunt to be a special Superior Court judge, and he stayed in that role until his death in 1999. Upon Justice Meyer leaving the court and Exum leaving the court, Burleigh Mitchell became Chief Justice, and he stayed in that role until he left the court in 1999 to practice law in Raleigh. At that point, Henry Frye became Chief Justice, but he was successfully opposed by Beverly Lake Jr. in 2000 for Chief Justice, and Justice Frye then went back to Greensboro and joined a law firm where he practiced until his retirement several years ago. John Webb stayed on the court until 1998 and then practiced law with his son in Raleigh for the next decade. Willis Richard retired also in 1998 and went on to serve as Campbell Law School Dean and in private practice, where he still is in private practice in Chapel Hill. Harry Martin, upon his unwilling retirement, he became the first Fourth Circuit mediator in the United States Court of Appeals for the Fourth Circuit in Richmond, and then he became Chief Justice for the Eastern Band of Cherokees. Beverly Lake Jr., as I mentioned a minute ago, became Chief Justice in 2001. He stayed in that role until 2006 and was instrumental in the creation of the North Carolina Innocence Commission. Upon his retirement, Sarah Parker became Chief Justice until her retirement from the court in 2014. And let me end where I began with the postscript on partisan judicial elections. 1994 turned out to be the breakthrough electoral year for Republican judicial candidates in North Carolina. Both Beverly Lake Jr. and another Republican named Bob Orr from Raleigh both won election to the Supreme Court as Republicans in their statewide races. The pendulum continued to swing. By 1999, Republicans had claimed a majority on the Supreme Court. Somewhat remarkably, in light of the strong history of Democratic control that we've talked about, by 2002, Sarah Parker was the only Democrat left on the North Carolina Supreme Court. But North Carolina is the ultimate purple state, and by 2016, Democrats had reclaimed a majority on the court. So now I think it is safe to say that North Carolina is truly a two-party state, not only in the legislative and executive branches, but also in the judicial branch. So I will stop there. I think I've hopefully not exceeded my time, but I do appreciate you listening. I'd be delighted to try to answer any questions you might have about the book or about our court today. But again, it's called A Warren Court of Our Own. I think copies are available in the History Museum Bookshop. It's also available on Amazon and on the Carolina Academic Press website. So Stacy, let me turn it back over to you.
Thank you, Justice Davis. Wow, that's so fascinating. So much amazing information. We have a couple questions. The first one is, throughout your research for the book, what was the most shocking or rather unexpected fact that you came across?
I guess the most, still amazed as many times as I've given a talk about this book and as much time as I spent researching the book, the 62% reversal rate in death penalty cases still amazes me. I mean, I cannot emphasize enough what a staggering percentage that is for reversing death penalty cases. And again, there was some justification for it in light of decisions from the U.S. Supreme Court that threw that area of the law into the state of flux that it existed in. But still, that's a really, really large figure. But generally, what really surprised me was just the deep-rooted philosophical divisions among these members of the court, which really just fascinated me. I mean, again, you know, all of them had similar upbringings in North Carolina. You know, all but Justice Frye were Caucasian. Everyone but Beverly Lake during that 1 year was a Democrat. They had so much in common demographically and politically, and yet that they just had these such different views on the proper role of judges, which to me, again, is just so interesting. And the fact that this strong division in consensus on how judges should do their job and how they should decide cases, you know, you kind of expect that type of conflict in high-profile constitutional cases. But just the fact that it carried over into all these different subject matters, like workers' compensation, which again is so rarely a controversial area of the law. But on the Exum Court, it really was controversial. You had justices who passionately believed that the other side was interpreting the law and applying it incorrectly. So generally speaking, that was probably the biggest surprise to me. Thank you for the question.
So our next one is, since a number of Confederate monuments have been removed across North Carolina in the wake of protests this summer, do you think that this issue might possibly, the issue of monument removal, might possibly come before the Supreme Court?
I do. I enjoy giving talks around the state, like most of us do. And, I always love hearing about what's on people's mind. And we always caution groups we talk to that we love talking about the court, but we're not allowed under the Judicial Code to talk about either issues that are currently before the court or likely to come before the court. And I do think that, we live in a time where perhaps more so than ever, both in North Carolina and nationally, a lot of so-called political issues are finding their way into the courts. Obviously, courts don't sit to decide political issues. We only decide legal issues that are presented to us in the form of a live case or controversy. But so many of the hot-button political issues that are going on in our society today have legal issues intertwined within them. And frankly, it would not surprise me at all if a case involving the monuments issue was to make its way to the court. We really are just seeing virtually everything that comes up in the news eventually make its way to our court. And judges don't necessarily like resolving so-called political issues because we really don't think of ourselves as politicians. We think of ourselves as independent. We take very seriously the oath we take to apply the law fairly and impartially and not be beholden to any political party. But we have to take every case that's brought to us, whether it is a so-called political issue or not. If there's an actual legal issue that's brought to our court, we have an obligation and a statutory and constitutional duty to decide it as best we can.
Absolutely.
Long answer to a good short question. Sorry about that.
I have a question here. What was the foundation for the work at will doctrine?
Boy, that's a good question. I've not had that question before. I really cannot give you a specific answer. I mean, I can sort of make a general guess. Employees historically did not have a lot of rights. I mean, the protections that we think of today and as basic to our law and our society for employees, a lot of that is a really recent phenomenon. And historically, employers had much, much greater leverage over employees in virtually all facets of the employment relationship than they do today. And I suspect it was just generally accepted by society, by the government, and by courts that if an employee did not have a contract, contract rights have always been given great respect by the courts, but I assume the thinking was if an employee doesn't have a contract, then why shouldn't the employer be able to fire them for any reason or no reason? The laws at that time were definitely pro-employer rather than pro-employee. And I do want to say that, for good or bad, whether you like the rule or hate the rule, employment at will still exists in North Carolina. This exception that I've talked about that was created in the Coman case, it's an important exception, and it's still very much part of our law. But employment at law, the doctrine generally still does apply. Generally speaking, employees who do not have employment contracts can be fired for any reason. And obviously, when I say any reason other than race, gender, ethnicity, et cetera, I'm just talking about firings that do not implicate any federal, statutory, or state statutory or constitutional prohibitions.
Okay.
It's a great question.
We have time for one more question, and this is, what is the best way to know about people who are running for seats on courts? I guess, what is the best way to educate yourself?
Yeah, it's hard. I always appreciate it when people ask questions like this because, judges do like being anonymous. We sort of like doing our work, but the reality is in states like North Carolina where we are, we have to be elected and reelected. When that time comes around, we'd like people to know more about us and know our names. And websites are a great way to learn about the judge. Every judge on the ballot these days has a website. You can find out more about that judicial candidate's background, what they've done professionally and personally, and you can find out the groups and individuals who have endorsed them. That's a great way to learn about the judges. Also, voter guides. We're seeing a lot of voter guides recently in recent years, which I think is great because it gives people another resource to use when looking at judicial candidates. And I believe the News and Observer just actually published a voter guide yesterday online that probably will come out in a print version within the next few days. And I think other newspapers around the state either have done the same or are about to do so. And that's another resource people can use for finding out about those who are running for judicial seats. So thank you for that question as well.
Awesome. Well, thank you so much, Justice Davis, for your time today and for speaking to us about this. It's been an incredible program. I've personally learned a lot. I hope that all of you have as well. And as we said, Justice Davis' book is available through the museum shop if you'd like to check that out. And it will be autographed while supplies last. But thank you so much again, and thank you all for joining us today. Definitely join us later this month, Wednesday, September 30th. We will have Ernest Dollar from the City of Raleigh Museum joining us as our History and Hygiene speaker. So check out our social media pages for updates about that. In the meantime, all of you take care, stay safe, and have a good rest of your day. Thank you, Justice Davis.
Thank you all so much. Thank you, Stacy.
Take care.